We're gonna go live.
Yeah, go live, please. I'm sorry, Peggy. I'll never remember going live. My biggest,
We're live.
Peggy knows. I forget.
We're live.
All right, good afternoon. Since joint Legislative Justice Oversight Committee meeting. Section 8 of Act 28 or S91 dealing with competency examinations asked this committee to review whether Vermont laws to permit competency examinations of defendants under 13 VSA 4814, in addition to psychiatrists and doctoral level psychologists trained in forensic psychology, to be conducted by other doctoral level mental health providers, psychiatrists, nurse practitioners, or any other professionals. And we had added to this committee are 2 members of the Senate Committee on Health and Welfare and 2 members of the House Committee on Health Care, appointed by the respective chairs. And on or before November 15th, the committee shall recommend any changes that deemed advisable to 15 BSA 4814 to the Senate and House Committees on Judiciary, the Senate Committee on Health and Welfare, House Committee on Health Care, and the House Committee on Human Services. So what Ben has done is a short slide presentation. So I thought we'd have him kick it off since he was our last witness, scheduled to be the last witness, but maybe better that he goes first.
Sure. Thank you, Senator Sears. Ben Novogrodsky from the Office of Legislative Counsel. I'll share my screen and go through the presentation that's before you. But really, as Senator Sears said, so it's pretty short and sweet, and it's really just more of a reference point as we talk about some things for you to have. We'll go from there. So, fitness to stand trial, competency exams in Vermont and other states. So, as Senator Sears just went over the committee's charge, basically, should Vermont law expand to allow other doctoral level professionals outside of psychiatrists and doctoral level psychologists specializing in forensic psychology? That was just added this past session through S91, which I believe is Act 28, and has a sunset of July 1st of 2024, just the psychologist edition. And then the goal of the committee is to recommend any changes it deems advisable to the governing statute, if any. So the bottom line, who should conduct competency examinations in Vermont? So what are they? They're governed by 13 VSA 4814 and the surrounding statutes. And it's an evaluation of a defendant's competency to stand trial. So there are 2 questions that are asked in this inquiry. Is the defendant able to understand the criminal charges? And is the defendant able to meaningfully participate in the defense to those charges? As I explained earlier, psychiatrists and doctoral level psychologists trained in forensic psychology conduct the exam. What it is not, though, is an assessment of the defendant's sanity at the time of the criminal offense. That's a separate inquiry, and a lot of the statutory changes that were made in S91 help to delineate the 2 inquiries. So going forward, competency is something that can be raised at any time through trial by the defense, the prosecution, or the court on its own. It is a threshold issue. It's not a defense to the charges like insanity can be. It's really just whether or not it's a threshold issue. Everyone can be there and really be a part of the case and their defense.
I thought this one would help me understand what is probably common knowledge to the judiciary folks. Is this the sole person making the determination that they're incompetent to stand trial, or is it debatable, or does the judge decide based on their?
Well, the judge ultimately makes the order, but there's sort of a process that goes along. So For instance, if the defendant is found incompetent by the psychiatrist or the forensic psychologist, there's a commitment hearing that's scheduled. To determine whether or not that person is a danger to themselves or others. So that would be a different, essentially an escalating inquiry.
Okay. But that one person is the only person who can determine if they've been found incompetent first.
I'd have to check, but my understanding is that they can offer, I think, a competing expert, if you will. But also competency is something that that's fluid. So they may be found incompetent, but if they regain competency and have another exam proving that, they can go on with the charges against them. And that's what this last point kind of touches on, is that someone who's found incompetent who later comes back into competency can then be recharged with the crime. So that's, again, different than insanity, where if you're deemed insane, it's a complete defense of the charges.
Is it this, because clearly I'm just asking all these questions because this person becomes really important, like their skill set becomes really important. So are they the same ones who have to find the person competent again, or you could get a different expert?
So
say, you know what, actually they're competent.
So it would be, again, the defendant, the prosecution of the court who would, order or move the court for an examination. And it's whoever the court appoints in that instance. And let me review the statute after this, just because I know that there is a process that addresses your issue. I just can't recall it off the top of my head at the moment. I do see that there's a hand raised on the screen.
Is there a hand raised?
I don't see it. Can't see the screen.
It's from...
Yeah, Karen Barber, for the record, General Counsel of DMH. I can answer your questions if that's helpful.
Sure.
So they are not the only person that decides. So they are, the competency evals that are done by the Department of Mental Health are neutral evaluators, right? And so they do make a determination as to what they think. But at any time, the defense or the state can hire their own, and they can contest competency. So just because our evaluator says competent doesn't mean the defense can't hire one that says incompetent, and then there's a hearing, and then the court makes a decision. Works the other way as well. So if we find incompetent, the state can hire their own that says competent, and then there will be a contested hearing, and the court would make a determination.
Okay.
And it is not always the same evaluator. So sometimes it could be. So if the department is ordered to do a second evaluation, sometimes it would be the same evaluator, but sometimes it wouldn't. It just kind of depends who's available.
Thank you. Okay.
Continuing on, and the point that Ms. Barber just made is really, from my understanding, the threshold issue of why this is there. It's availability of the provider, essentially. And my understanding of sort of the policy dilemma that came out of the session was, on the one hand, making more people available because there is a backlog of competency examinations and those who are available to do it. And that's weighed against expanding that to people that may not be as accurate in their competency. So that's sort of the policy considerations facing all of you.
Can I ask clarifying, just based on what was just mentioned, it's the Department of Mental Health currently that would do these competency evaluations with the psychiatrists that are currently licensed to do this, but they're through the Department of Mental Health. Is that correct?
That's my understanding.
That's what I just understood.
Well, we have a number of witnesses.
Yeah, and I would defer to the...
But if we expand it, they would still have to be with the Department of Mental Health.
But I do think...
Arrange them.
Yeah, unless they're arranged independently by the defendant. I do think that it's otherwise through the prosecution, through the department. And just for...
Ben, can you talk a little bit about what it means to be competent? I mean, some is frequently confused with insanity, and so competent, what competency means in terms of understanding the judicial process and so on. We'll talk about that.
Well, it goes back to really those two fundamental questions from the previous slide, which is being able to adequately participate in your defense. So interacting with your attorney, being able to give approval to certain legal strategies, if you will. But then there's the initial threshold question is being able to understand the charges against you. And so this goes into, I mean, just a basic level competency of really just, I mean, understanding not just what the consequences are of being charged with these crimes and potentially being convicted of them, but also what goes into that, what the court process is, what's entailed in that. So, and that's different than an insanity defense, which again is something that is really the end all be all. It's a complete defense and not something that's assessed. It's an insanity defense that's assessed at the time of the crime that was committed. Competency is at the time of trial. So you may be, again, incompetent at one point in time, but then later regain competency to undergo the process.
It doesn't matter if you're competent at the crime.
Correct. It's all about at the time of trial.
At the time of trial, but insanity is at the time of the offense.
And again, part of the statutory changes was to help kind of make the distinction between those two different inquiries.
They used to be combined.
Right.
Were at first.
And so just as a comparison for some other states and who's permitted to do these exams in New York, it's performed by a psychiatric examiner, which can be a qualified psychiatrist who has a degree, certified by the Board of Neurology and Psychiatry or eligible to be certified by the board, or a certified psychologist who's registered as such under New York law. So they also permit other psychologists. It's not as narrow as the sunset that was done in S91 where it's someone trained in forensic psychology, but it does permit for certified psychologists. In Rhode Island, my understanding is that Rhode Island is the only other state that, like Vermont, until this most recent session, only allowed psychiatrists to perform the exam. And so again, conducted by a psychiatrist or physician licensed under Rhode Island law. And then Oregon has a little bit of a different process, but as far as who can perform the exam, it's done by, again, a certified examiner who completes forensic evaluator training program, and that can be a psychiatrist, so one licensed by the medical board in that state and completed a residency program in psychiatry, and then also a psychologist licensed by the board of psychologists in Oregon. So just for some comparison purposes. Any other questions?
I just want to be really clear. This is, you only apply competency exams in criminal cases, not family court, not juvenile court.
Correct. In this context, okay. Yes.
Well, no.
Well,
There's a gray area.
yeah.
A little different.
Yeah, it's a little bit different, and juveniles are always treated a little bit differently than adults. So it is different, but this is just about competency in Title 13 and who can conduct the examinations, not necessarily who is subject to.
So this is all adult.
Any other questions?
I'm just curious, having not had testimony on this in my committee about, were there suggestions in testimony about who the other professionals might be?
That I don't know because I was not a part of those procedures.
I guess it was a Senate bill, so I'll ask.
Was the psychologist.
So somebody other than a doctoral level psychologist, is that what they're?
No, a doctor.
Doctoral level forensic.
So aren't they already able to do that?
No, they weren't until this year, and They now, and it's sunset for next year, so.
Oh, okay, the
We'd
sunset.
have to make a recommendation, but the problem, part of the problem is the lack of psychiatrists to do the evaluations. And the second problem that we heard about was the number of people who don't make the appointments. There are scheduled appointments that take, 4 or 5 hours to do the competency evaluation, and the people don't show up.
So, yeah.
You heard more than we did on that.
Yes, we did. And so we did hear a lot of testimony, and the result was, we'd like to have this joint committee look at the issue and provide a recommendation. But I think, correct me if I'm wrong, I think there's one forensic psychiatrist who does evaluations in the state right now. So expanding it made a lot of sense.
Yeah, no, I'm not against
no,
expanding
no.
it. I thought we already had, but it just passed this year. I mean,
Workforce issue,
yeah.
supply and demand.
Yeah, doctor level psychologists honestly might have a broader understanding of competency.
Exactly.
Yeah.
What I'm not seeing here is that we have a board that certifies who's qualified to do this examination, like exists in some of these other states.
It's through their professional certification.
Okay,
The
so
license.
Yeah,
I didn't know, it looks like,
psychologist through OPR.
so
And psychiatrist through.
that's what we're talking about in these other states, is the
I would
same
think so.
licensure.
Then-
It's not an extra layer of like, yes, you.
Yeah, exactly. So
Okay.
a psychiatrist that's, can practice through the medical board here, or has been given a license, a psychologist that's been given a license through OPR.
Okay, so these, the other states didn't add a layer of approval.
No, I mean, Oregon, of the ones that I studied, has that required sort of forensic training course, but that's something that's separate and apart from the licensing of their individuals. So that's just a policy choice that state made. And as far as who we're talking about, Representative Wood, in the charge, one that's explicitly mentioned is psychiatric nurse practitioners as another doctoral level practitioner that could be considered, but it's open-ended to read any other medical professional that has a doctoral level certification.
Yes.
Along your lines, does the person have to go through OPR, their regulations?
Psychologist.
For your licensure.
Yes.
For the
But
licensure?
if you're going to get there are a lot of certificates that you could get after any licensure and after any degree. So that Ben will clarify, but so they can go through the certification process for forensic analysis. So it's an educational certificate.
Do they have to do it within a specific period of time, like OPR says you gotta do supervise the work and so on within 5 years? If you don't do it, you don't get it.
I don't think that's part of it. It's an external certification. It's not an OPR certification. OPR,
So this is over and above that.
yeah, it is, exactly. You get your license through OPR and you have your license through the Medical Practice Board.
Yeah.
And then you can go ahead and study other things that allow for you to practice within your profession. So as a forensic psychologist or a psychiatrist.
Yeah, you're spot on. That the license itself is done by either the medical board or OPR, but the certification in forensic psychology, that's something that would be.
And who does that? I don't get that.
There are trade groups. I'd imagine that there's the American, Association of Psychologists, things like that.
We could ask the next witness.
Yeah.
Commissioner of the Department of Mental Health. That way. No, thank you, Ben.
I did see that Representative, what's her name? I'm sorry, Burbico.
Oh, Rebecca.
Yeah, I was just wondering, maybe if Karen could speak to the competency evaluation itself and whether that is something is it administered with a tool, or is there some sort of objectivity to it as we think about what level of clinician or training is required? I'm curious just how standardized the process is.
And then we have a question from our Senator Gold.
Oh, so
Do
you'd
you
like
want
my
me to
question
answer
now?
now? Oh, sorry.
Yeah. No, go ahead.
Okay. So it depends, right? There is no like set test. There are certain things they are looking at. But I think one of the things to remember is you can be incompetent for lots of reasons, right? It could be a mental illness, it could be a developmental disability, it could be a TBI, it could be substance use. So it really depends on what the person presents with. One of the reasons why getting records in advance is so important is because the psychiatrist has a sense of any past history, and so may have a sense of where their questions need to be. You know, currently, if someone has an intellectual disability, we refer that to a psychologist because they can do some more specialized testing. But there's no kind of set, every evaluation looks the same. It really depends on the person's clinical presentation.
Did you, okay, Representative Gold, did you have a question for Ben or for somebody else?
It's a general question. OPR pays attention to scope of practice so that when a clinician does apply for a license, the medical board as well, you have to state your scope of practice. And I was wondering if forensic examinations might be part of the scope of practice in this context. So that's a question that I'm curious about.
Okay. So why don't we go with Karen Barber? Is Emily Hawes here or just Karen from DMH?
Just me.
Just you. Okay, fine. Karen, go ahead.
Good afternoon. For the record, Karen Barber, General Counsel of the Department of Mental Health. We did submit some written testimony. I don't know if you had a chance to
I'm sure we do.
review that. So the department doesn't take a position on whether or not you should expand. What I can do maybe is answer your questions that may be more helpful and talk you through where we're at. One of the things I will say, because there's been a lot of questions about their qualifications. So DMH sets qualifications for people we contract with. And so I was just pulling up our last RFP. So we require that someone hold a current license in the state of Vermont. We require that our psychiatrists are board certified. And then we also require some level of additional forensic training, which could be a forensic psychiatry review course offered by the American Academy of Psychiatry and the Law. I can't tell if I have feedback or someone's asking a question. Just feedback.
Just feedback.
Okay. Or that they write a sample competency and sanity eval that we review. So we do set kind of quality parameters. The same with the psychologist we use that does the intellectual disability evaluations. I don't have his RFP up in front of me, but again, we do require some level of specialized training just to make sure that that the people we're hiring are licensed in the state of Vermont and do have the specialized training and are able to do these evaluations. The other thing I can say that was talked about in our memo is that we do currently have 16 evaluators, 15 psychiatrists, and then we have the one psychologist that we have that we had before the statutory change. We have not enlisted any more evaluators. As I had kind of mentioned in the past, for us, it wasn't so much the number of evaluators, it was the process that was taking a really long time and it was administratively burdensome. We did just this week roll out a new process that we hope to really streamline our ability to do evaluations, and we're hoping we can do up to 15 a week going forward under the new process. We do, when we submitted this memo yesterday, it was numbers from Friday and we had 88 on the wait list. Right now we have 75. I just checked. So we are working. We've scheduled 17 in the last week. So we are working to move through the wait list as soon as possible. Again, the problem is not necessarily that we don't have enough evaluators. It's actually trying to get them scheduled at this point. There are a lot of really great changes that were made in S91. We don't fully know the impact of those yet, but we are working on tracking that data much more closely. We do still have about 25 sanity evaluations that we need to get through. So we haven't yet seen the benefits of that. But we have, based on the new changes, and Novotel was able to retain many more psychiatrists than they were before. Just to give you an example, pre-COVID, we had 5 evaluators. We now have, as I said, 16. So we are rolling out the new process. It is going to hopefully be less administratively burdensome on the department and allow us to more quickly schedule these evaluations. I think one of the things to remember, right, is this is just a very small part of what the department does. And this is scheduling these evaluations is a huge administrative undertaking for one of the paralegals in the legal department who has many other job responsibilities. So she is working as quickly as possible as she can. We're working on getting her some support and again, streamlining that process. But right now we don't necessarily need more evaluators. What we need is to kind of figure out a process so that we can be referring them more quickly. One of the things we've asked of the court is to make sure they're getting all the documentation right off the bat. So that's not a delay. One of the things we've asked defense counsel is to get back to us more quickly about whether or not a date will work. In the past, we were just kind of waiting until we heard back. We've now set kind of a 48-hour deadline. And if they don't accept within that time, then we're going to move on and assign that time to the next person. So we're really thinking about how we can more quickly do things. I hope to be able to come back in a couple months and have more of an update, but it's too early right now to see what actually, how the new process is going to roll out, but we do anticipate it having a significant impact on the wait list.
There's different testimony than we heard this winter.
Not from me, but yes, I know the Defender General did feel strongly that psychologists made sense, and we respect that, right? From our case, we've always felt that it was other issues causing some of the delays, and we do think a lot of the changes in S91 are the changes we asked for, such as the orders, separating competency and sanity, making sure we could get the records, issuing the bench warrants if someone's don't show. Those are all the things that we really felt like we're going to have an impact. And we do anticipate that they are going to have an impact. We're just starting to kind of slowly see that.
Thank you.
So I'm always curious about places where bias or some discrepancy can creep into the process. So my question, and maybe you can help me if I'm not understanding this clearly, if they come through your office, is that because there was, it's a public payment for this expertise, as opposed to if they hire their own private person to make the evaluation? Is that sometimes because the legal team can afford to hire a different expert? And do you monitor any trends in the people that you hire, if some tend to find more competency or incompetency? Do you sort of track demographics of what they find, and if there's any age, gender, or race discrepancy in who's deemed competent or incompetent? I'm just trying to better understand where someone could use a new category of evaluator to, if they have money or resources, be able to hire somebody, as opposed to what your office does, which is it a public process? Are you hired by the court, therefore you're paid by the court, and there's not money exchanging hands from the person who's hiring an attorney?
So the court doesn't pay or hire anyone. It's all DMH, right? They'll make a referral to the Department of Mental Health and we arrange for it. So there's a couple different ways, right? You can get an evaluation. The court can order DMH to provide a neutral evaluation. Yes, or either party can go out and get their own and they're free to hire who they want. I think what you heard was a lot of testimony from the Defender General that they tend to hire psychologists. It's just like in any other case, right? You're allowed to get your own expert. If you're recommended by the Defender General, then the Defender General pays for it. The state, the state's attorneys have a budget. So certainly, I guess, yes, if you're also, if you have private counsel, then you're kind of privately hiring them. But other than that, it would be the Defender General's office or the state's attorney's office who are doing it. We don't dive real deep into the data as to who's found incompetent and who's not. Again, these are not necessarily folks in DMH custody. They may not even have a mental illness. This is a very small part of what we do. We do look kind of trend-wise. I think about maybe 50% of those ordered are found incompetent. I'd have to double check. But we kind of look at it that way. We are trying to think about what data may be more helpful to collect. But again, we're not a part of these cases. So we don't necessarily know what happens, right? Once they're found competent, we are done with it. If they are found incompetent, they may ask to see if they qualify for DMH services, but they may not, right? Because again, you can be incompetent for many reasons. So we don't necessarily know the outcome of these cases and we're not a party.
Hi, I'm not a standing member of this committee and a bit of an interloper today, but I do have a question around scheduling. It seems really important, and I'm wondering if you can speak a little bit to what the administrative burdens are around scheduling, other than it sounds like the friction of time and distance are problematic, but I'd love to hear a little bit more about that.
Sure. So what was happening was that we'd get a request. Sometimes the court would send the relevant information we needed in terms of like the charging documents and the affidavit. Sometimes they wouldn't. And then we work to go to our contractors and say, we have these evaluations. They give us dates and times that work for them. And then what we were doing is then going to the defense counsel and saying, hey, would this date and time work for you? And then they contact their client, and it could be a couple days, it could be a couple weeks until we hear something. And then we would try to schedule it, assuming those dates still worked for everyone. And then if we didn't have the records, the evaluator maybe couldn't finish the evaluation because they needed the records. We get a lot of no-shows. If the person doesn't show, then that's all this time wasted. No one else can be fit into that spot. And the wait list is moving. So the new process is that we're not going to go back and forth about dates and times. It's too administratively burdensome. It means we can only refer, a limited number a week versus just sending out a mass. So what we're going to do is we're going to get a date and time from the evaluator. We're going to give that date and time to the defense counsel. If that works, great. If it doesn't, then we'll schedule them the following week and hope that works. But we need to much more quickly move through because we have one paralegal who has got many more things than just this she needs to do, that was spending all of her time on emails trying to coordinate people's schedules. And it just wasn't working. It was really causing those delays. The other thing is, we're counting on the defense counsel to try to contact their client. A lot of times they can't find their client. So we don't know if they're going to show or not. And then if they don't show, there was no consequence for them not showing, right? It just would mean our evaluators didn't want to take these cases because they were losing that money. And it meant that time was wasted because evaluators set aside huge chunks of a day to do these that no one else could use at that point because it was too late. So we're also going to ask a week in advance that people confirm that they can still do that date and time. And if they don't, we're going to assign it to someone else. So ideally, we're not losing so much. So again, we're asking people to be a little bit more involved and help us out a little more so that hopefully we can more streamline the process.
Thank you.
So
Yes, done.
Karen, the problem that's being solved through the legislation, Act 28, was to place the competency hearing prior to any assessment of insanity. So that's one problem that's being solved to go forward, and I think the courts are very thankful that's happened. And then if someone is declared incompetent to stand trial as a result of the evaluation, what happens?
It depends, which is a very lawyer answer. But it depends, one, on why.
We love those black and white answers, clear answers. Sorry, go ahead.
So the biggest thing is it depends why they were found incompetent. So was it a mental illness? And so if so, then they'll reach out to the Department of Mental Health and we'll think about, is an order of non-hospitalization appropriate? Is an order of hospitalization appropriate? If they had an intellectual disability, is an Act 248 order appropriate? If it's substance use or dementia, we don't really have involuntary programs for those. So it really depends on the needs of the person. One of the things we were also asked to look at in S91 was the potential for competency restoration, and that could, potentially change how things go right now, how things go in the future. But right now, Vermont does not have any sort of restoration mandate. And so no one is actively restored to competency. That doesn't exist. They may get there as a benefit of treatment or just engaging, but there's no, we're not trying to restore them to competency, even if they were to come into, say, the DMH system or the Dale system.
And then one further clarification, which we probably hear from Dale, that an individual with an intellectual or developmental disability would be evaluated by someone who understands those areas.
Yes, so that would still be DMH, right? So DMH is still the one that hires the forensic psychologist. So Dale doesn't have anything to do with competency evaluations. They may end up receiving custody through Act 248 at the end of the process, but they are not involved in the initial process at all. It's solely DMH that holds those contracts. But yes, if there is a suspicion of an intellectual disability, then we use our forensically trained psychologist to do the evaluation. If we know right away that may be an issue, then Dr. Donnelly is assigned right away. If we're unclear, then we would first assign a psychiatrist. And if the psychiatrist says, hey, actually, I think that what I'm seeing might be an intellectual disability, then we would ask Dr. Donnelly to do the evaluation. So they are getting specialized evaluations, but again, it's all through DMH.
Thank you for clarifying. I'm a little confused by the Dale role. They don't come into it until after the psychiatrist or psychologist would find that the person has an intellectual disability.
Correct.
So they're not even, that's how somebody gets to Act 248.
Right. That's after there's been a competency determination.
Is there any victim involvement?
In the competency evaluation process or in the Act 248?
I meant in the process. They know, do they have any?
I do not, apologies, I do not know much about the Act 248 process, so I am not sure. So I can say on the DMH side, no, like if someone was getting an order of non-hospitalization, there wouldn't necessarily be any victim involvement, right? Because it's a clinical determination about whether or not someone needs our services. I don't know how that works on the Dale side. It could very well be different.
Okay, thank you. Yes.
This might be a question for those who heard this testimony, but first, Karen, in addition to being legal counsel, are you a licensed mental health professional in any capacity?
Me personally?
Yes.
No.
Okay. I didn't ask that as an attack on you, but I'm looking around and who we're not hearing from are mental health professionals about what this change.
This is our first hearing on
Okay.
this that's going to take 4 meetings
Okay.
to get through. And
So I guess then that's why I
right
thought,
now, we're having the
Yeah.
mental health and then explaining what our charge is. And
okay,
then I expect at our next meeting, we'll hear hopefully from mental health professionals
right.
as well as.
Great. I mean, my only comment in this context is hearing from DMH that they feel like the problem was not a personnel related problem.
It's a court issue. The courts were finding confusion about having, I can't speak for the court, but certainly the confusion around having competency hearing and insanity hearings going on concurrently and trying to put it into a stepwise progression.
Yeah.
So you're either competent or incompetent to stand trial. And then if you do stand trial, did you have sanity at the time of that you committed the crime?
Right.
So what we're doing now is understanding that there was a backlog, whatever the cause of the backlog for the competency hearing. We're hearing from Karen that some of this is being resolved for whatever reason. That's good to hear. But until next year, we have forensic psychologists as well as psychiatrists performing the competency hearing. So there's a lot going on and things are being pulled apart and solved at the same time that we're still trying to solve the problem.
Right. So I would just in the future meetings want to make sure that we're not letting a quality question be answered by a logistical question, that changing the timing is different than having different types of professional who can make this determination.
Right, but when you have a backlog, then you also want to consider numbers of professionals who are available to do that analysis. So it's a catch-22. You do one or you do both. And so now we're actually doing both. So see how it goes. And Ben, remind me, it's a preponderance of the evidence that must be demonstrated to demonstrate incompetency or competency?
I believe so. I need to, which
Okay.
side of the issue, let me check for you.
Did your committee hear, your committee was the jurisdictional committee?
Came from judiciary
Okay.
to our committee, so we work collaboratively.
Did you hear opposition to this change?
Not opposition to psychologists.
Okay, so psychiatrists didn't come in and say they don't have X, Y, or Z.
No, I
Qualification.
think at the time we recognized, goes back to the testimony this morning about mental health care in the institutions. There's a shortage of professionals and that's part of it.
Thank you. I was just going to add that there is going to be an all-day conference coming up about mental health in the courts, and that might be something that would be really useful.
And you're all invited.
Yeah.
Might be, I forget what the
Yeah, we
date.
have Judge Zone coming up shortly, but first, if there are any other questions for Karen, but we will hear from the medical society at the very least, as well
They
as
did have
who
concerns.
represents psychologists.
Psychologists.
What group?
I'll find out.
It's not the medical society.
No.
It's got to be a group. And psychiatric social workers.
Yes.
I'm not sure. Our next witness is Defender General Matt Valerio. Thank you, Aaron. Matt, good afternoon.
Let me just get this on.
You are on.
September 14th.
Yes, and thank you for having me. I am Matt Valerio. I'm the Defender General. This suggestion of having psychologists do forensic competency evaluations was my suggestion. This arose out of initially a shortage of individuals who were available in the state of Vermont who were by statute recognized as competent to do these evaluations. Vermont was one of only 2 states in the nation that didn't allow or recognize by statute doctoral level psychologists from performing forensic competency evaluations. The other was Rhode Island. And we had a shortage and a backlog. And I'm glad to hear that apparently Department of Mental Health has more people who are available to do the evaluations, and that the backlog has trimmed significantly from 6 months ago when we were having this discussion in the legislature. There were a number of questions and comments that I heard during the prior 50 minutes or so of discussion that I was hoping I could clarify. One of the things that I did want to clarify is that competency is an issue also in juvenile cases, that is in juvenile court and hence the family court. Doctoral level psychologists have always been approved for use in competency evaluations in those cases, but it had not been recognized in Vermont in criminal cases. What the defendant or defense counsel, because it's, you know, we do almost every case in criminal court, but not every case in criminal court, uses forensic psychologists oftentimes to attack the positions of the psychiatrists who come up with their evaluations if we don't feel that they're appropriate. And that might arise that probably arises out of the court-ordered evaluation. And the court has to make a determination based on what they hear in evidence of whether or not the person is competent or not. So it's a full-blown evidentiary hearing on whether somebody understands the proceedings that they're taking part of, whether they can adequately participate with their counsel in defending themselves in these cases. And as Karen Barber indicated, that can arise out of a bunch of different areas, whether it's a major mental illness, traumatic brain injury, developmental disability, or the like. Ultimately, the qualification to do competency evaluations, whether an individual is qualified to do that, really rests with the court. But because there has been a presumption that psychiatrists are statutorily authorized to do it, where there is a balance to be made, oftentimes the psychiatrists would get the nod one way or the other when the court is trying to make a decision. That whole situation is contrary to really what the nation does, except for Rhode Island. So we believe that for a bunch of different reasons that, and again, I wouldn't have made the suggestion if I didn't think it was going to be beneficial, that doctoral level psychologists appropriately should be used to deal with these cases. Now, the other side of this is it's not just about the initial evaluation that perhaps the Department of Mental Health through the contractor is doing regarding these evaluations, but it's the availability of individuals to all of the members of the criminal justice system, whether it's the prosecution or the defense, test those evaluations. It's not a monopoly that Department of Mental Health has on doing these evaluations, and they really don't have or shouldn't have a horse in the race of whether somebody's competent or not, but it's the availability of competent people to test the evidence that's out there, whether it comes from the Department of Mental Health or anywhere else. And so the more people we have available to do it, and competent people, and I suggest that doctoral level psychologists is one of the areas that is probably, that's where I would like to see it go. I don't, there are some states that allow master's level clinicians and other types of licensure to do these evaluations. And I don't suggest that we go there. I think a doctoral level of evaluator, psychologist, clinical psychologist, or PhD level psychologist is probably that's about as far in the kind of the credentials as I would want to go. I wouldn't want to go any lower than that's I think going to be helpful ultimately. It is way too soon right now to make any evaluation about whether or not this is assisting the system. That's always one of the kind of the frustrating things is a law gets passed, goes into effect on July 1st. And then on August 8th, we have a hearing to see how it's going. And basically, nobody's had a chance to take a breath as to what this is all going to mean and be implemented. So as far as we're concerned, we've been supportive of it, and we're interested to see how it pans out. We've actually been using, as I said, doctoral level psychologists to test the practice of the psychiatrists for decades.
You use the term test the competence of the psychiatrist?
Yeah.
Yeah, I picked that one up.
It's interesting because psychiatrists and psychologists do very different things when they evaluate an individual's competence to stand trial. Psychologists are trained in administration of a number of different instruments that have been tests and the like that have been validated. That's part of what they do. The psychiatrists don't administer those tests. They have sort of clinical evaluations and talk to the people about the legal elements that are part of it. So oftentimes when if you're a defense counsel or if you are a prosecutor and you didn't like the result of the mental health, independent mental health evaluation, you'll hire a PhD or doctoral level psychologist to pick apart the clinical evaluation of whatever happened with the Department of Mental Health. And the doctoral level psychologists are very effective at doing that because they have more tools at their disposal to make that determination. That's kind of in the weeds for you folks as legislators, but that's the facts as to how these cases, when they're contested, how they proceed. I don't know how I did receive the department's proposed memo on scheduling and the like yesterday afternoon. I will be interested to see how that works out.
Senator Robbins still has a question.
Well, I hope there's some respond to this, but what I'm hearing is that there might be a different reason to allow psychologists to engage in these competency exams besides the backlog, that they might actually be more qualified in certain instances to do the evaluation. And I would rather have that conversation than one about scheduling, if that makes sense. And so I guess my question in that is, if the Defender General's office has availed themselves of a clinical psychologist now that it's allowed in this pre-sunset period, because it was the better evaluator versus, like, do you see a case coming up where you'd rather have a clinical psychologist and you feel like that would be a better decision, not like whoever's available first kind of thing?
We've actually been doing that for decades.
Well, you said for decades, but you've been doing it as an understudy to the person who has to write off on the evaluation. Is that right?
Not really study. We have done it as part of litigation to attack the opinion of the psychiatrist who did an evaluation that we don't feel is appropriate.
So this goes back to my original question for Ben, which is the importance of who gets to do this. So you're saying that right now in Vermont, a psychiatrist is the only one though that can go into court with that initial determination of competency, but you can attack their report with a clinical psychologist.
Yes, the only thing right now that is the independent evaluation that is ordered by the court through the Department of Mental Health prior to the passage of the legislation that you just passed was a psychiatrist. Passage of the legislation, qualified doctoral level psychologists, and they may be clinical psychologists, they may be PhD level psychologists. There's the PSYDs, there's the PhD level psychologists. Both of them would be qualified to do these evaluations in the first instance, and what we are hoping is to attract more of those people to the state, because we've had a turnover and a large number of retirements in this community over the last couple of years.
I know. I think I'm more confused about the problem we're trying to solve, but.
Problem we're trying to solve
Yeah.
was the backlog, but also whether or not, because of the backlog, which may or may not no longer exist, would it be, who should be doing these evaluations? And so we put a sunset on the psychologist to get this information and take testimony.
Well, it's the backlog, to be clear, I think the backlog still exists. It's just not as enormous as it was a year ago or 6 months ago. And it's really
there were about 80 of them backlogged up, and people were
80 instead of 160.
Right. And people were spending time in jail because they had to wait for the competency evaluation.
But the only person who can do the initial competency evaluation has to be through DMH?
It's court
They arrange
ordered.
them, yes.
If it's court ordered.
It has to be court ordered, yeah.
Has to be court.
So that's why if DMH is saying we're neutral, but we're still only using.
No, they said they were neutral to the psychiatric social worker and others.
Right. Oh, so they're not neutral.
I think they were in favor. We can check with Karen, but I thought her testimony was in the letter indicates they're in favor of the psychologist.
Oh, I thought she came on and said they're neutral about it.
Well, the question is, do we expand?
I read the letter as being in favor of the current statute and lifting the sunset, if I could put that.
She's come back on.
So they're.
Karen's here.
Yeah, the departments, DMH and Dale, do not have a position as to whether to expand evaluators beyond forensically trained psychiatrists and psychologists pursuant to. Yes, so they're.
So beyond what's now allowed for the sunset.
But let Karen speak to that.
Double negatives.
Read your letter.
That was basically what I was going to say. We don't really, I think Matt said it really well. We don't have a dog in the fight, right? Like it doesn't, our job, right, is we get by statute, we have been told that this is what we need to do. We hire evaluators, we do the competency evals. We do not have, our role is to assure that people who need mental health treatment get it. As to whether or not someone's found competent and who's appropriate to find them competent, we really feel like we're a neutral in this, and so we're not taking a position on it.
Let's go back. Is that clear?
Well, it is, except what I think I heard was that you're still almost exclusively using psychiatrists. So do you feel like there's situations where a psychologist would be a better person to evaluate competency that they're not getting a psychologist, they're getting a psychiatrist?
In cases of intellectual disabilities, we do use psychologists.
Okay, but you weren't before this law?
No, we were. Yep. No, that it was allowed. I think what changed now is that psychologists can also do people who have primary mental illness. We are continuing to use psychiatrists for that, but we use psychologists when intellectual disabilities are indicated.
Okay. So it doesn't seem like it's going to be a major change.
Matt, you still any comments further?
I'm sorry, Senators. Say that again.
Any further comments from you on this issue?
Yeah, I was around obviously for pretty much every part of this, and I know that there are obviously members of this committee that weren't part of that testimony, and the horse was beat pretty dead about this issue of the doctoral level psychologist. I didn't think that there was any I didn't think there was any opposition, and I didn't hear even opposition. I didn't hear opposition from the psychiatrists who testified or anybody else. The question, as I understand it, is whether it should be expanded to people beyond doctoral level psychologists. And I would not be in favor of that, but I would perfectly fine play out. And again, we've had a month so far, so it's a little early to make any evaluation. The only thing I'd also want to comment on, I had on my list here, was, but I do know that what psychiatrists in the past, who finds everybody competent, who doesn't find everybody competent. We didn't break it down on a ethnic background. This question was brought up earlier, but we definitely know who the ones who are more likely, just as a matter of statistics, to find somebody competent versus not.
So it's like you could be judge shopping.
Yeah, except for we don't assign any of them. So,
and it's called psychiatrist job.
Somebody's assigned out of the Department of Mental Health, and the name comes up, and we say, "Oh, that one is very, very likely to find this person competent." Then we have to be more. We have to take a look at that closely and see what we're going to do with it.
Do you use Vermont or out-of-state psychologists when you're?
We have used both, depending upon the appropriateness in any given case. There are people we bring up from Harvard, McLean Medical, who are, one of the guys is a behavioral pharmacologist, and he's actually a PhD level psychologist who talks about drug interactions and how they work with mental illness, and that's somebody he's not a Vermont guy, but he's one of the world leaders in that area. We bring him up. There are people from around who they're not just from Vermont, but the statutory presumption of psychiatrist is something that really was only part of Vermont and Rhode Island law, and we thought it beneficial that if we could get in line with the rest of the country.
I have one more, I'm sorry. Maybe I've had too much caffeine. So Representative Emmons helped me understand that the second part of the question is whether others would be included. And so I guess my question for our Defender General's office is, do you see, the only reason I could think of including others is because there's not a lot of diversity in terms of who is a doctoral level psychologist or psychiatrist. We struggle with that a lot in the mental health field writ large for people of color. I can probably think of other discrepancies too, but it's a huge discrepancy among someone you might find that's a Black mental health professional or otherwise. So I just wonder, in your perspective, if you think there are cases where you would want expertise from somebody who has a perspective that might close disparities beyond people who are licensed doctoral level psychologists or psychiatrists.
I haven't thought about that, to be honest. I would hope somebody who's a doctoral level psychologist or psychiatrist would have training to recognize those issues. I don't know that if you had a master's level person in color looking at the issues that you would be any better or worse off. I don't know the answer, honestly. Haven't thought about it in that term.
Well, maybe let's not think out loud about it, but if you could come back with an answer, any empirical studies, or we could ask the medical community, that to me is the question I want to answer for that second part is there a gap? Because it's very hard to make it to your doctoral level of psychology or psychiatry if you come from a marginalized background.
I think one of the questions to ask is really maybe a little bit flipping that. So is there sufficient diversity within our doctoral level psychologists and psychiatrists to account for providing adequate representation for these evaluations for people of color?
Yeah. I would like to know that. Yeah, exactly.
Well,
We don't, I mean, right now, we don't know.
Matt?
Yeah, no, that's the
Matt,
question.
did you want to comment?
It's probably a better question for the doctors, to be honest.
I agree. Final question from me is there geographic disparities in terms of, or is it just individual psychologists or psychiatrists who find competency or not?
Yeah, with mental health now using the the video evaluations over computers, that issue is less of an issue. The issue that arises more is the availability of and how people are kind of respond to the video as opposed to in person. But I don't think it's as geographic as it used to be. I think it is more facility with technology and just comfort level with using that. Many of our clients, and this is what I foresee, by the way, with the proposal that the Department of Mental Health has with these data. Many of our clients are transient. Some are homeless. They don't stay the same place over and over. They are either they do or they don't have some level of mental illness. They aren't particularly reliable when it comes to their scheduling, or their ability to read. I think that I guess if everything was a perfect world, the department's memo with these 48-hour deadlines and the like are, that would be wonderful if that would work. I just don't think that's the way our clients work. And so we're either going to have a lot of arrest warrants, or we're going to have, there's going to be some level of disruption with the clientele that we deal with anyway, that are, qualified to have competency evaluations and getting them scheduled. And that's part of the world we live in, I think. So while I guess we would aspire to be able to work with the Department of Mental Health, I don't have great hopes that our clientele are going to be amenable to that. But we'll see, because I got it yesterday afternoon, so we'll see what happens.
We'll be back to this and hopefully hear from you later.
Can I just ask?
Any other question for Matt Valerio?
Oh, no, mine's actually for Karen. can ask her a question.
Another question for Karen, if you're available.
Hi, thank you. I'm just curious if there's any background questions or information that's gathered from the person to be evaluated in order for the department to understand whether or not you need to seek an evaluator that has some potentially, specialized skill or background that would be relevant to assess. So whether it's a person of color or an LGBTQIA person or like you were talking about, a person with a disability, it seems as though that was considered for people with developmental or intellectual disabilities or brain injury. I'm just wondering if other characteristics are taken into consideration when assigning or requesting an evaluator.
No, so all we get, right, again, we're not a party, we're not at these hearings. All we get is a referral from the court, which generally includes the charging documents and an affidavit that talks about what the crime is. We may know the person, which is why we may know a psychologist is indicated, or it may indicate they can ask for a psychologist, they can indicate there's an intellectual disability. Again, I think the thing to remember too is, this is competency is a legal question, right? It's, do you know how to talk to your attorney? I don't know how much, they're not super in-depth evaluations, right? It's not like we're doing a mental health assessment where we're really trying to think about what programming does the person need. It's very different. Are they competent to engage with their attorneys? So we don't have a lot of background information. We're not even in court when these are done. We just get, the court emails us, we take it, and we just assign it. We don't tell people, we're not picking certain psychiatrists based on who we think, right? We send it out and whoever can take it, takes it. The only difference is that if there's an intellectual disability, we assign it to a psychologist, but otherwise, whoever gets it, gets it. I will just quickly respond. I know that there are times when we do hear from mainly the defense bar that they have a concern with an evaluator. If we do get that, we have our own medical director read the evaluation to see if she has any concerns. And then we also, Novotel has a head psychiatrist who oversees. And so we do, if someone raises a concern with us, we do make sure to go back and make sure we feel comfortable with the evaluation, but we don't assign special psychiatrists for certain people.
So I'm presuming you have interpreters available for people with different languages.
We do, yep.
Okay, thanks.
A question from Representative.
Rebecca.
I couldn't pronounce, I'm sorry. Barbo.
Okay. Someone earlier mentioned Novotel. Karen, I think it might have been you. I'm curious if DMH is using Novotel clinicians for evaluations remotely via telehealth, and if you are you using Novotel scheduling services too to schedule those?
No, we schedule them.
Have you considered using Novotel scheduling? Because I know they offer that. I'm just curious whether that might help with addressing some of the backlog.
We haven't. We have not. I don't know the logistics of that. Again, I think most of the delay is just trying to make sure that we're working with the defense counsel to find a date. But could we do that in the future? I don't know.
Okay, thank you. Okay, Tim Waters-Dumont, the representative of the state's attorneys.
Hello, Mr. Chair, and I think I'll be pretty brief because you've already had the experts going in front of me. And so, yeah, I think we're very hopeful that many of the changes that S91 put into place will eventually bear some results for all the different parties. And in the question about victim notification, as long as it's allowed by law, our victim advocates inform victims as to every step of the process when there's a criminal justice involved individual. And, we do think the S91 will be helpful in the competency evaluations going forward. We were supportive of the bill as it passed. And we agree with the Defender General's perspective that it's important to have as many qualified evaluators as possible for the state to make sure that individuals are being evaluated as soon and as close in time to potential court hearings as possible. That said, if there's going to be an extension of the sunset as to doctoral level psychologists or an expansion that this group considers, I had sent along a mostly technical recommendation to Attorney Novigrowski that you then also amend 13 VSA 4816E, which is the presumptive allowance of relevant portions of what was previously just psychiatrists' reports to include whatever the list may be. So if it's doctoral level psychologists, which it is now, or other individuals who are professionals in this area, that 4816E in Title 13 is amended to reflect whatever the list is. And next session, we would recommend that 13 VSA 4816E include doctoral level psychiatrists if the sunset will be extended. And I've sent that along to Ben, so he has it as well. But really, that's the extent of our comments. We're meeting every couple of weeks with DMH and Dale to make sure that if we can be helpful on anything, we will be, and we're certainly interested in seeing if there's any progress that can be made in competency restoration going forward.
Do the state's attorneys have any recommendation regarding those other than doctoral level psychologists?
We leave that in your learned hands, Mr. Chair.
Thank you so much.
That's what we need to that's what we need to weigh in on. Yes.
Okay. Any questions? No. Hey, that was brief, Tim, and thank you very much.
Thank you all. Good to see you.
Forward to seeing you coming south one of these days.
I look forward to that as well. The Blue Ben, I understand the menu hasn't changed, so I know exactly what to order.
Hasn't changed in 100 years.
Exactly.
Well, actually it has, but it's still the same old Blue Ben with a new owner. They're doing a great job. Our next witness is the Honorable Judge Tomei.
Good afternoon.
Are you open today?
We're in a different location, but we are certainly open for business today. It's good to be here. Tom Zoney
usually has a sign behind him saying open.
Yeah. So I too think I can be brief. The judiciary supported the expansion to include the doctoral level psychologists for the evaluations. And I think what I've heard during the discussion this afternoon ties into the idea that, well, perhaps people started to look at this because of the backlog and because of the delays. But the question really becomes, even if you took that out, is it the right direction to go in? And if you look at 40, the other jurisdictions, they go there. I believe 48 of the other states were already there. And they found that having a broader pool than just psychiatrists enabled the effective administration of justice. And from contacts with my colleagues across the country, when I've asked about the timelines, I am sorry to report that the timelines between getting reports in Vermont and getting reports in other jurisdictions don't match. We take a lot longer when we had the backlogs, and even in the normal course, I suggest, we took longer to get our reports and evaluations. I believe, for instance, New Hampshire requires that if someone's incarcerated, the report has to be submitted within 45 days. If they're not, it's within 90 days. There are jurisdictions that have actually much tighter requirements than that. And by expanding the pool of qualified individuals, you're adding a diversity to the evaluators that doesn't exist with just one discipline of psychiatrists. And you're affording the opportunity to have more reports done by more people, thereby shortening the time frame so we can get the cases into court sooner. And that loses part of the issue that we heard about from Mr. Valerio also, and that is you lose touch with people when they have extended periods of time. We saw that during the pandemic. So the more we can do to shorten those time frames, I suggest that it will also mitigate the potential of defendants losing touch with their attorneys, perhaps. And it should help all of us move forward in the criminal justice system, not just, again, to address a backlog, but to keep the system moving with case flow as efficiently and expeditiously as we can. And as far as lowering, I won't say lowering, as far as expanding who can do the evaluations, I was just looking at a document put out by the National Center of State Courts from a number of years ago, and they mentioned that there are some that allow master level with licensure, mental health professionals with forensic training. I'm not prepared to weigh in on whether the Vermont system should go any further than where it has right now. But we do support the idea of the doctoral level psychologists continuing not just during this period, but after the sunset.
Questions for the judge? Judge, thank you very much. Appreciate it.
Thank you. Have a nice day. Take care.
So Judge Zoney, I do have a question. I'm going to follow up on Senator Ron Hinsdale's question. And the question is any data that you keep, is there any data that you or perhaps it's the Department of Mental Health keep with regard to who is declared competent versus incompetent based on gender, gender identity, race, ethnicity? Is that pertinent data that you have, and do you see that as an issue in the process of competency determinations?
We do not keep that data, and it would be difficult to assess whether it's, if you will, an issue in the process right now, because I don't have the data to compare it to and to understand and see how things came out. But we do not keep that type of data. I would note that the judiciary does have a commission on diversity, equity, and inclusion. Justice Cohen is working on a committee that is dealing with data. I submitted a report last year to the legislature regarding certain types of identifying and demographic data relative to civil cases. And I know that the DEI Commission is looking into different areas for data. So I will mention this inquiry to Justice Cohen and see if it's something that they are looking at.
Thank you very much. That would be very helpful.
Great. Thank you all so much. Appreciate
Thank
it.
you.
I'm wondering,
There's the baby.
I'm wondering who you would like to hear from besides someone from the American Psychological.
I think it's the Vermont chapter.
American Psychological
Association. I believe that would be appropriate.
And the Vermont Medical Society would probably have psychiatrists.
The testimony that we heard from the psychiatrist affiliated with the Howard Center would be useful.
Okay.
And perhaps to have a doctoral level psychologist who's currently involved with it.
What about the other groups that were mentioned in the legislation?
So, and then beyond that, I think OPR might be helpful in identifying master's level nurses. Who else was in?
Psychiatric nurse practitioners. I didn't have my glasses. I didn't bring my glasses.
You didn't bring
today.
your glasses?
Thank you. No.
Mental health providers, psychiatric nurse practitioners.
Maybe a local
or other
mental,
masters,
maybe
yeah.
hearing from a local mental health center. You said the Howard Center.
Yeah.
Yes.
So when we were taking up S91, I was contacted by a doctoral level licensed psychologist who I think we should probably reach out to as well. He could serve that role. He is familiar with these issues. His name, I don't know, it's possible you've heard from him as well. Thomas Powell is his name.
Yeah. Well, he used to work for the Department of Corrections, so I know who he is. I think he may have reached out, but we can certainly, Peggy can get in touch with him. Who else?
Martine.
I have a question because now I'm very confused. But before I say that, before I ask the question,
I do sometimes wonder if historically there's a little bit of bias toward or against psychologists and psychiatrists. It has come up in our Health and Welfare Committee before, and I just want to throw that out there. My question though now is, it seems, or what question are we asking now?
Well, the legislation requires us to consider whether or not to lift the sunset on the psychologist.
Okay.
And whether or not to add other professions to the list. And that's where the other professions come in. Now, whether we heard from actually Matt Valerio that he thinks psychologist is enough. And we heard, I think, Tim agreed with him. And I think Karen was neutral, and Judge Zone, I don't remember I don't think he took a position.
I think he said lift
The sunset has not been lifted yet.
No, that would need to be in legislation next year.
Because the sunset's July of 24.
July of June 30th.
24. Thank you. So we can lift it, or you can extend it for another year?
Or do away with it.
Do away with
And
it?
be like the other 48 states.
Then the next question is, do you then expand the evaluation to these other entities? Then one thing that, was it Tim mentioned, or was it Matt? Someone mentioned about the timeframe.
Yeah.
That some states have.
Right, I think
Timeframe.
Judge Zone did, and I think that's probably something to consider as we consider recommendations, because the testimony we heard, where, probably in judiciary, was that those waiting competency evaluations were in jail longer on detention than any other group, other than those with charges that, like murder, that would take, a long time to resolve.
Are any folks who are required to go through the evaluation, are any of them held at the state hospital? Or are they all held in DOC?
I don't know. Can anybody answer that that's still on?
Is that Karen?
I can. So it depends. You can be ordered to have an inpatient evaluation or an outpatient evaluation. If you're ordered to have an inpatient evaluation, we have a psychiatrist that then assesses the person to determine whether or not they meet hospital level of care. If they do meet hospital level of care, then they would go to an inpatient unit, wouldn't necessarily be BPCH, could be any hospital. If they do not qualify for an inpatient, but instead get an outpatient evaluation, they could be in DOC or just in the community.
So Karen, I know we're talking about a future possible forensic unit. Would any of these folks who are waiting for a competency evaluation or have been deemed incompetent to be housed at the forensic unit?
So the way the legislation was written at the end of last year, it would be only for people that have been found incompetent or insane. So it wouldn't be before that determination was made, and then it would be only for people that were incompetent or insane. Does that make sense?
It does. So right now, if someone has been deemed to be incompetent to stand trial, are they housed at the state hospital or at DOC in a correctional facility?
So again, it depends on their clinical needs. If they're incompetent, they wouldn't remain in corrections. The reason we propose the forensic facility, right, is because there's a gap between the folks that need hospital level of care and those that do not, but still remain in need of intensive services in a secure setting. So right now they could wait in a hospital. Again, doesn't need to be VPCH, could be any hospital throughout our system. If they need that level of treatment, right? It depends on their clinical need, not whether or not they're incompetent. Or they could be in the community or in some sort of residential setting. If they are on an Act 248 order, then Dale provides services to them.
So there is an S89, I forget the act number, working group right now looking at the gap issue. So there's another working group looking at who would
Go into a forensic unit. Wasn't that in 91 or was it in 89? 89.
It's in, yeah, I'm on that.
89. What's the act number for that?
Act number.
80, yeah, 27.
Thank you.
Jesus. Yeah, I keep confusing 89 and 27. I thought it was a route number to come up here.
So you went on the wrong street.
91 and 89 are.
But at any rate, that issue is whether or not developmental disabled
Right,
would be
that's a Dale.
Right, that
Dale
was.
issue.
I'm staying silent. I'm staying silent.
That was you. There are three of us.
Make sure support services are available appropriately, or if there's a number of questions that are being asked over their hands. And Stuart Shore is the expert in that area, but I think that's
Yeah,
not part of what we're doing.
No, we're not,
We're not
Justice
there.
Oversight's not taking that
We're
up.
not
We have a
taking that.
special committee for that. You were on that one too.
We're going to go
I
crazy.
wrote down a meeting for the second meeting. I wrote it down for Wednesday and I was online and all set to go on and they wouldn't let me join the team. Because I was the wrong day. I missed it by 2 days.
It's easy to do.
Oh, yeah.
Okay, we don't have meetings scheduled. I think we have an idea of an agenda for the next meeting, but we also have other issues we have to take on. But we don't have a meeting scheduled yet for September, October, November, December. So Peggy will do a doodle poll to everybody. And then for our guests, we can send you the doodle poll. That would be helpful. But I think we'll at least do one more meeting on this question, although I found it pretty helpful today what the practitioners had to say.
Did you do the thing for, what was it? The letter?
Yes.
And then we have the letter.
I can, I can send it to, but I can send it to the committee.
Why don't you send it to the committee?
Should we act on that today?
Well, it'd be helpful if we could talk about it briefly.
You want me to share it on the screen?
Yeah, why don't you share it on the screen? That's a heck of a lot easier.
Yeah.
I strive for it.
Was this the letter of recommendation?
Yeah, for the public immediate situation.
So the question that some of my committee members had was whether or not they should be voting on this letter of recommendation, since the healthcare and human services participation and healthcare and human services, both House and Senate, was specific to Act 28
Yeah.
competency. So we would not vote on this letter. Okay.
That's okay.
No surprise.
Nothing again yet.
Go ahead.
You can deal with it come January. You got a heads up.
A bit more.
How about that? Better than I could have written it. Oh, yeah.
That's what he gets paid the big bucks for.
Huh? What do you think?
I'll move that we approve and send.
Senator,
We call it programs in the second line. We call it program in the first paragraph, so if we could just be consistent. I think that second, it's the fourth line, the first paragraph, the first word, I think it should be programs in, and it says programs in the second, so. I like the plural personally.
So I'm just wondering, should we,
Thanks, a journalist.
should we, in that second paragraph, ask them to, I mean, we heard from these two areas. We don't know what the status is in the other areas. Should we be asking them to look at the status in other areas?
that's in the last sentence, isn't it?
Yeah. Oh, across the state. I missed that. Okay. Okay, thank you.
So I'll second that motion if nobody else seconded yours, Martin.
Did you make them?
Yes, yeah, I move.
Just second. All in favor, say aye.
Aye.
Opposed? Well, it's unanimous.
That was quick.
Are we going to get a copy of that letter?
It's,
Yeah, I can mail it out and then it'll, right now I have it by regular mail and email to the commissioner. That's fine. Okay.
Sounds good. Is there anything else? We'll do the doodle poll, and Peggy, if you're still with us, if you send the doodle poll to all members, including those health and welfare and human services members.
Thank you for including us.
Pardon?
Thank you for including us.
by statute.
Oh, oh, it wasn't just a nice gesture.
Some of the house came up with.
So if it's required, they came.
Oh, you did it?
So if they're required, they put in for per diem,
Yes.
Jenny?
I would assume.
You should put in for per diem.
Yes,
because
you
they
should
were
put in for per
required
diem.
in expenses.
Well, I think
How's that?
he does that,
It's on our way.
What would you rather have?
but
But he
it's
said,
not.
I'm getting 200 heads of notes.
But thank you for reminding me, because
We got an email saying they put in for us, but I'm not sure.
And I hope there's no one get it.
still online.
Thanks, everybody. Good to see you all.
I know that Connie and Peggy are working through it now.
Sandra,